you guys need to be aware of. One is that the amendments, there's sort of a discrepancy between the first paragraph and the last paragraph, because it says that the seller warrants in the first paragraph, and in the last paragraph it says it's the buyer's responsibility to still look and check. So I want to kind of go over that with you, but I also want to go over with you the information on the form. The seller is warranting the cost at closing for the transaction, okay? So the intent is that if the seller doesn't properly disclose the fees for the community management associations, whatever they are, and for the communities, then the seller is responsible for whatever those fees are. And the whole theory behind that was really what Jay and I deal with constantly is we get these letters, or we call and we get an estimate, if you will, of what the costs are going to be, so that we can give Jay an estimate on his disclosures. And so what ends up happening is we finally get a letter right before closing, or a few days before closing, or whenever they will release it to us, and that letter has a whole bunch of other fees on there that we didn't know about. So then Jay's done his 3-day disclosure, and then we come back to do the final closing disclosure, and the final closing disclosure is different than the original 3-day disclosure because they didn't know about HOA dues, and neither did we. So you think, okay, order the letter earlier. Well, we can certainly do that. The problem is that most of the letters are only good for a specified period of time. And they charge to update those letters, many of them. And so we don't know, we actually have some management companies that from subdivision to subdivision, that cost to update the letter changes based on their agreements with the homeowners associations that they're dealing with. Sometimes it's only a $25 update, sometimes it's another $150 update. And we've seen it both ways, so we don't know which way it's going to go, so we're trying to keep from having the buyer and the seller paying too much in fees. Now, we had at one point said, okay, what about updates if the seller's paying the letter fee, and all the fees for the closing, what about updates? And a lot of you were doing an amendment to the form that said that they will pay for the first fee, but any extensions for the closing or whatever that are not the seller's fault, the buyer would have to pay for those updates. So now we're in a situation that they have to guarantee it. So I'm going to give you an example of what we had happen. We had a client that we were trying to help her get the numbers out first and foremost. Every time she called the management company, they were saying, order a letter. She said, I don't even have a contract on my house yet. Order a letter. If you want to know our fees, you'll have to go online, you'll have to order a letter. Well, I'm just going to tell you, most homeowners have no idea what they're doing when they order the letters, okay? It is pretty problematic. In our office, we order the letter, have it set up, give you a number, a control number, and then your client goes back in and buys and pays for it. Let me tell you what we've just had happen with one of them. We set up the letter, we printed it out, the information. The buyer goes in to do it a little while later, literally like 5 hours later, they go in to pay for it, and the fee is now higher. And the management company said that it's because you didn't pay for it right when you processed the thing. Well, they didn't process the letter. They printed it on a screen. The letter wasn't processed. So now they're saying if you don't pay for it when it's set up, there's an extra fee. And they argued and argued and argued, and they finally went to the homeowners board, and they got it waived. Here's the problem that you're going to have. When your sellers call to get these numbers, and I'm begging you not to do this, do not call the management companies and get these fees and give them to the seller. Why?
Because then we are the middle person and ultimately.
And what's going to happen? Your seller, when it's not right, your seller's going to want who to pay for it?
Us.
That's right. Your seller needs to find this information out. And I'm in the process of creating a form that I've used a couple of times with a couple of different people so far, just kind of testing it. What we are doing is we're going to provide a form to Dana that she can put on the intranet for you guys that you can use. And it's the Homeowners Association Community Questionnaire, basically, is what it is. And it says specifically on there, Community Association, are there any fees charged at closing for proration of Homeowners Association dues? What is the annual cost? Are there any special assessments coming due and payable? It has on there, is there an initiation fee? And then it closes it up with, after all asking all these questions, is there any other fee charged for the community association that needs to that the seller needs to know about or charged at closing? The next section is for management company. Is there a management company involved with the collection of the homeowners association fees and letter? And then it says, is there a letter fee charged by the management company? Is there a convenience fee? Is there a transfer fee? Is there a account closure fee? all these crazy fees that they charge, and it ends with, are there any other fees charged by the management company not listed herein that will be charged at the time of closing? We are already getting a lot of pushback from the management companies on this form, from the few people that have tried to use them. We've had 2 of them tell us they will not fill them out. If you want to know the information, pay for it. So my response to you is, get your clients going to their boards. We have a lot of people that will then go to their boards, and the boards will waive it. You know, get the management company to waive it, because the boards get shocked about how much that they're charging and that they want them to pay for this letter up front. And by the way, if you get a letter, most of the time that letter is not going to be good by the time you do it pre-listing to the time that you do it once you go to get a contract and we go to close. We're going to have to order a whole new letter. Unless the management company tells us that we can use that current letter, and I'm going to tell you they're not going to miss out on those funds. If you want to fight this, you need to be writing letters to your local state representatives and your state senate people. You need to contact your state legislators on this. Do one letter and copy them all on it and give them examples of what you're seeing in your closing with some of these fees. I have no problem with what they charge for these. My only issue with this is they're not disclosing these fees to the Homeowners Association board when they sign these contracts. Their contracts are very vague, and they don't say that we're charging all these extra fees. And 9 times out of 10, when you talk to the boards, they have no idea these fees are being charged. The other problem I have is that they're charging them up front of closing. They can charge them at closing, but they don't want to lose out on those funds because they were preparing a lot of letters and files were falling through. So I understand that, but it's real estate, and none of us get paid until the work is completed and the file is consummated and closed. So my whole point to you guys is there's more due diligence for your seller in this. This needs to be in your listing packets. You need to have this questionnaire or some questionnaire that you come up with in your listing packets that you need completed and maybe attached, you know, or put in a file. Like if you leave folders out or the information out, put it in there, whatever. But you need to have this done as part of your listing packet, and don't wait until you get a contract to do this stuff. One of the questions I keep getting is how do we handle when the annual dues are higher? Because right now is the time that they're getting the new dues notices. So a lot of people a lot of communities are raising their dues this year, maybe $50 from last year, $100 from last year, or whatever. So I've kind of reached out to a bunch of attorneys to kind of get what sort of everybody's going to do on this. And what the consensus seems to be is the prorations will be based on what the seller discloses. So if they just disclose $500, but then going forward, the buyer's going to have to pay the additional cost because it's their responsibility to double check and make sure these numbers are right. So if it went up to $600, the buyer's going to pay the $600 going forward. The seller's not going to pay an extra $100 a year for as long as the buyer owns the property because it got disclosed wrong. And sometimes they'll get this information and the dues maybe don't come out till March, April, or May, and they haven't raised the dues yet. So sometimes this information may be wrong based on when they get the information. We've had a lot of problem with this. I actually had a client come in the other day and I sat down with her and we called together the Homeowners Association Management Company. Now she'd already had several conversations with them about this. And all they kept telling her was there was an initiation fee and the annual dues were $750 and they would be prorated at closing by the closing firm. It was a management company that I deal with all the time. It's a very well-known management company. And so I said, no, there are other fees. There's a transfer fee. They have a convenience fee. They have all these extra fees you have to pay if you pay your fee online. So I get on the phone with her there and ask the proper questions. And they had a transfer fee of $110. They had a $75 account closure fee. They had a $10 letter fee. They had a convenience fee of $5 for the letter when it was paid online. With your credit card, all these different things that they had not disclosed to her, because when she's asking the question, they're only disclosing what the community fees are and not their management company fees. So you need to be really careful about this because your sellers are going to get hit with these numbers. We've already seen it make a difference on a closing. We had a closing last week on a brand new contract, and the whole thing came up that these were not properly disclosed, and it was almost $1,700. And their lender had to go because it was back to underwriting because they knew that the number was going to be close to what they needed to put into the new deal. And so we're sitting there waiting on them to go back to underwriting to get the net proceeds for the seller fixed because it was less than what they had anticipated based on the preliminary numbers we had already given them. Because when we don't know, you don't know what you don't know. So So that's it for the community association.
I have
part
a
of it.
question, Amy.
Sure.
What if the community association disclosure exhibit is not included in a contract? What do the closing attorneys do at closing regarding any of those fees?
Well, it really comes down to what the parties agree to. And one of the things that we can look at is we can try to look and see if it's in the seller's disclosure. Do they have anything that's written in there? We try to look, okay, is there anything that was given to them? The problem is we're seeing a lot of contracts right now that don't have that information, don't have that form attached. I don't know why it's being missed, but a lot of them are not attached in the community association disclosure form. And so what we try to do is get them to complete it and agree on who's going to pay for it as soon as we know it's a PUD, and go back and tell them, look, this isn't attached to your contract. We don't know who is supposed to be paying for this information. Typically, most letters are pretty specific on what the fee is for. So if it's a transfer fee into the association, it may be labeled as a buyer cost on that letter. If it's an account closure fee, that's obviously a seller cost because it's a, a fee for the closing of the account. So it just depends on what it says. And, we try to deal with that as far up front as we can when we get the contracts and we get the title back. But we are seeing that missed a lot.
Thank you.
You're welcome. You know,
And I was gonna say, guys, I've had to completely restructure a deal at the closing table.
Yeah.
Because of fees, because the borrower didn't have the money, we didn't have it verified. I mean, just disaster at the
Yeah.
closing table for stuff.
So, and the hope is that this will prevent this and then at least make it the